Last night on the program, we spent a lot of time talking about the case out of Kenosha, Wisconsin, involving 17-year-old Kyle Rittenhouse. He's the 17-year-old accused of murdering 2 people, shooting 3 people during the Kenosha riots. Now, there was something that came up during the hearing, and we didn't go that much into it last night, but I want to take some time tonight to talk about it because it goes to a bigger issue of what this case is about and how this case has impacted the nation. And take a listen here where there's just a little bit of an argument here about a pro hoc vichy lawyer. Take a listen.
We have a couple of matters here that I wish to address first. First off was the issue of the request for admission, pro hoc vichy admission for 2 attorneys, I believe Mr. Pierce and Mr. Calderon.
The timing, Your Honor, was that the defense had filed a request or a motion for those attorneys to be admitted. The day after that, our office had written a letter to the court indicating that we would be objecting to it and asking for a hearing. A few days after that, Judge Schrader went ahead and signed the order admitting them, and then apparently noticed that we'd made an objection and contacted us and indicated that this is something that is normally granted in the course of business, and that if the state had specific concerns, we should bring them to his attention. I have now filed a brief with those concerns.
This is unusual. I mean, the judge is right. I mean, generally speaking, pro hoc vichy, that means you are a lawyer, you're licensed to practice in one state, and you have a case in another state that you're not licensed to practice in. So you need to get a local attorney to sponsor you and bring you in, but you have to be approved by the judge. And in this case, it's very unusual for the lawyer on the other side to object to it, but it's happening in this case. So who are they objecting to? His name is John Pierce. He's a very outspoken attorney from California. He was the attorney during Kyle Rittenhouse's extradition hearing. Let's take a listen.
Your Honor, it's no secret that this is a very unique, extraordinary situation. There's a massive amount of video evidence that shows that there's, beyond a shadow of a doubt, that this is not a legitimate criminal prosecution. It is a political prosecution. There are serious issues with the extradition paperwork that, in fact, bolster the suggestion that this is a political prosecution. These papers were sent directly to the governor without us even getting a chance to look at them in the first instance without any notice. There is no reason to rush. There is danger to this detainee. There is a presidential candidate in the heat of arguably the most heated election perhaps ever, certainly since 1860, that has inflamed the situation. And we simply ask that this detainee's due process rights be observed so we can challenge this in the proper way and ensure that this is a legitimate criminal prosecution and not something else.
And that was from the extradition, which was in Illinois, and he had local attorneys who were sponsoring him there. But now the prosecutors in this case, they don't want Pierce to appear in Wisconsin. Now, subsequent to that, we've got a tweet from John Pierce. He does a lot of tweeting, by the way. And this one from December 3rd says, "So that it does not take Kyle's supporters by surprise, effective immediately, I am taking over all civil matters for Kyle, including his future defamation claims. I will also be orchestrating all fundraising for defense costs. The terrific Mark Richards will proceed in Wisconsin." And Mark Richards was the attorney that we saw appearing for Kyle Rittenhouse yesterday from his office with Kyle Rittenhouse sitting next to him. So it appears that John Pierce is out of the criminal case at this point. But that doesn't take away what is going on here because John Pierce, very outspoken, and there were papers filed by the prosecution that we want to dive into a little bit right now to see why they wanted to keep Pierce out and see what we can glean from all of that. Because last night I was talking about how the prosecution defense not getting along. This is more evidence of that. Let's bring in Court TV anchors Julie Grant and Michael Ayala. Thank you so much. I don't know if I've ever covered a objection to a pro hoc vichy admission issue, but it's for real. So one of the first things that they were talking about was the money. It seems prosecutors were concerned about the money because we know that Kyle Rittenhouse raised all his money to get out on bail and has to raise money for his defense. He's a 17-year-old kid who doesn't have money, and he's got private attorneys. And I want to put up on the screen, this is from the state's motion. And they said that shortly after he became the defendant's attorneys, Mr. Pierce stated publicly that he was stepping away from the Fight Back Foundation to avoid the appearance of an improper conflict of interest. However, Attorney Wood, Lynn Wood, who was another one of the attorneys, also represents the defendant and has stated that the foundation would still pay for Mr. Pierce's representation in the case. Attorney Pierce regularly uses his Twitter account, which has over 32,000 followers, to encourage people to donate to the Fight Back Foundation. So let me ask you this, Julie. Why do prosecutors care where the money is coming? This isn't like a money laundering case where it's like the drug cartel is paying for the lawyers. Like sometimes prosecutors worry about money there. Why do you think the prosecutors are concerned about where the money's coming to pay for the defense of Kyle Rittenhouse, the 17-year-old they've accused of murder?
Yeah, so you raise a great question, Vinny. So why should they care, right? The fact that they're opposing this motion for these attorneys to pro hoc in, and that term pro hoc vichy, it's Latin for this event, like you explained to me, they are coming in and want to represent this defendant, Kyle Rittenhouse. And so you would think every defendant in America who's accused, the Sixth Amendment protects them. They have a right to counsel. And so you wonder why the prosecution is so adamantly opposed to this. I mean, this brief, Vinny, in opposition to that motion to pro hoc in is savage. I mean, it really is. It goes after the attorneys, essentially saying that these attorneys shouldn't be allowed to be part of this case, Judge, because they don't know how to follow the rules of professional conduct. Wow. So this is quite an attack on character. I mean, lawyers have to follow those rules. They could be in big trouble and potentially lose their law license if misconduct is reported to the disciplinary board. And with respect to funding, I mean, a big fundamental rule of the professional rules of conduct is you can't commingle funds. And so if there is an appearance of impropriety that somebody who is doing fundraising might also be paid out of that fund, it does raise the issue of perhaps a conflict. And so here you wonder, well, why does the state care if it is? But, you know, hey, maybe they just want to, attack these lawyers. They don't want them on the case for whatever reason. And perhaps they're giving them a reason by this appearance of perhaps impropriety here. So I don't know why they're so opposed to this. I mean, look, they got to be concerned with their case. In my opinion, they need to get their evidence together and be ready to go to trial, because these attorneys, from what we saw yesterday, Vinny, in that prelim, they are loaded for bear to represent Kyle Rittenhouse.
Michael, do you think, and what I'm thinking is it's not so much about the lawyers, they want to cut off the funding of the defense, because if you cut out these lawyers who are raising the money publicly to fund the defense and to fund the bail and everything else, then perhaps, the defense doesn't get to do everything that they want to do in terms of investigation and experts, et cetera.
Yes and no. I mean, I hear what you're saying, and perhaps removing them from the case might slow the flow of money coming in, but does it stop it? I don't know if it does. The money's sitting there. It is for his defense, Rittenhouse's defense. It can still be funneled, right, to Mark Richards for while he's doing the defense, and he will handle the money the way Wisconsin says you have to. One of the things you have to do in Wisconsin when you're retained by someone, you have to put that retainer into escrow. And the idea is, again, that you protect the person who's coming and asking for you to represent them. So does it stop the flow of money? I don't think so. I think this is more of what you talked about. The political lines have been drawn. When you heard John Pierce talking in the extradition hearing, he mentions political about 5 different times. It's a political prosecution. And this has really been drawn along political lines. There's folks on one side, there's folks on the other. They're not necessarily respecting each other's opinion. They're not finding any common ground. And I think this is just more of that.
The other thing that got prosecutors really angry is the pretrial publicity and the fact that the lawyers were out there speaking and tweeting and talking about the case in a lot of different places, which is, it's not super uncommon in high-profile cases, but they think they went too far. So there's the rule in Wisconsin says that trial publicity, a lawyer shall not make an extrajudicial statement that the lawyer knows or reasonably knows will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Okay, so somehow what you say is going to impact the case. So prosecutors in their papers included examples of Pierce's alleged trial publicity rules violation. In the motion, it was filed on November 20th. The state included links to tweets and interviews, including this appearance on Fox News in September.
This is 100% self-defense, Tucker. Kyle, he's a good kid. He's a lifeguard. And I got to tell you, one this, Tucker, in this war zone, in this chaos that was occurring in a city in America, in the middle of Wisconsin, Kyle, the only individuals that Kyle shot were the 3 individuals that were attacking him and putting him at risk of serious bodily harm or death. This is a 17-year-old kid. This is amazing.
All right, Julie, so here's my question. I always wondered about this because different states do things differently, but prosecutors indict someone. A lot of times they come out, they announce the charges against someone, they read the indictment, etc. How is that any different than what these defense attorneys are doing by saying this is what we say really happened that night?
Sure, that's a really good question, Vinny. It's tricky. This is an area that's really not black and white. There's a lot of gray when it comes to media statements. Not every statement is equal, and there are certain caveats to different statements that come out there. And for instance, if you go to the American Bar Association puts forth a set of model rules of professional conduct. And I looked in the comments before coming on the show tonight because I wanted to see really where that kind of gets to the policy behind why lawyers have these rules that they have to abide by in the profession. And essentially it gets to the heart of balancing the right to a fair trial with the right to free expression. And so certain subjects generally have more of a prejudicial effect. Subjects like when you talk about a person's character, or you talk about a defendant's guilt or innocence, you talk about a criminal record of a party in a case, all those things have a more likely chance of causing prejudice to the jury pool. Whereas if you do something like announcing a motion to a motion for, continuance to continue a case from one date on the calendar to 3 months down the road. The harm that something like that causes, what harm is caused? You're just merely informing the public who has a right to know about cases and what is happening in the public realm, and courts are open to the public always. So that's really something not considered harmful. And I want to point out one caveat in the comments to the model rules that I saw tonight, and this was somewhat of a good reminder, and perhaps this is what these defense attorneys for Kyle Rittenhouse might be saying, and that is that sometimes those out-of-court statements are permissible when they're made in response to the other party's statements. And a reasonable lawyer believes that a public response is required so that the defendant isn't prejudiced. And here with a case like Kyle Rittenhouse's, there was so much media coverage and so many statements swirling out there. My guess is that these attorneys would probably say, hey, making an appearance like the one we just showed you is in response to trying to combat what's already been put forth into the public realm about our client.
Michael, they also included some tweets in the papers as well. Let me read two of the tweets. John Pierce tweet from November 7th. Saw Kyle today. Amazing, service-oriented, God-fearing America. He sends prayers to everyone and wants you to stay strong. He prays for those he had no choice but to defend himself against and their families. Please help this boy by donating to Fight Back. Then August 29th, a prior tweet. The Kyle Rittenhouse prosecution is the most politically motivated prosecution in American history. It is an outrage. Duke Lacrosse 2.0, except much worse. The prosecutors should seriously reconsider what they are doing. Kyle should be freed immediately. Fight back. All right? You have a problem with those tweets?
If he was an attorney on the case, I don't necessarily have a problem with it, but it's just an extension of what we're seeing in these culture wars, these media wars. Their position, and I understand it because I've been following it for a while now, and we see what's going on in society, is that the media is against Kyle Rittenhouse. And all these media presentations, politicians are all saying these things. It's not necessarily the other side. Now, remember, we just saw in the Chauvin case, there was a prosecutor who was taken off the case for making comments similar to these. So it's not uncommon for that to happen. You don't want that type of thing out there spoiling the jury pool. I think John Pierce is in the right place. He doesn't belong on the defense team. He's on the outside. He's representing him in a civil sense. It gives him the freedom to represent him in the media, on Twitter. And he can say those things without finding himself in that difficult position as his actual criminal defense attorney. Now, he's still straddling a line, but certainly he's got a lot more latitude.
Yeah, and one of their complaints, Julie, about the media, Michael makes a great point, the media against them, is that they were trying to raise money on some of the sites, whether it's GoFundMe, Twitter, Facebook, and they were getting taken down, but they were still able to raise all the money. So do you think in cases like this, Julie, it's perhaps smart to have, okay, on the one hand, you've got your defense team, on the other hand, you've got like your reputation team that's taking care of the court of public opinion?
Right. In this day and age, that's a good question. I've never really thought much about that. I know as a prosecutor, in just the office I worked in, we were always very, very careful not to make any extrajudicial statements. And I think most prosecutors feel that way for good reason. You don't want the case to be tried in the court of public opinion. You're a minister of justice when you're a prosecutor. You're not trying to go on Twitter and convince thousands of followers of your position. No, that's unethical. It's not what you do. And so, I think with a case like this, it's so high profile and can get so out of control so quickly. I think it is important that there is somewhat of a PR team kind of managing what's going on in the media and perhaps responding and maybe providing some of the information in the court file. I mean, there's nothing wrong with saying, hey, we just filed this brief, or this is our position, and this is what's happening with the case, the progression of it. And I think a lack of information and rushing to judgment is what we're seeing in a lot of these cases. And so I think if the PR team's job is to put forth what is already public in the court file and try to educate the public, then I think education is always a good thing, and reserving judgment until everything gets in the courtroom and the case is before the jury or the judge who are ultimately going to hear it. I think that's what's really most important.
What's interesting? You're talking about when you were a prosecutor. When I was a prosecutor, we didn't have the internet, so we didn't have to worry about any of this stuff. There you go. Julie Grant, Michael Ayala, thank you so much.
Thank you, Vinny.